Continuing on this episode of Law Weekly, agenda setting for the new leadership of the bench and the bar, I speak with a senior advocate of Nigeria, Kelechi Obi. Also showing on the program highlights on the issue of globalization and the legal profession as discussed at the recently concluded Annual General Conference of the Nigerian Bar Association. Plus a recap of the top stories from the courtroom. Hello and welcome to the program. I'm Shola Shoyele. It's a new dawn for the bar and bench in Nigeria with a change of leadership that has occurred at both levels. A few weeks ago, President Bola Tinubu swore in Justice Kudirat Kekere-Ekun as the acting Chief Justice of Nigeria, following the retirement of Justice Olukayode Ariwoola after he clocked the mandatory retirement age of 70. On this episode of the program, I sat down with a senior advocate of Nigeria, Kelechi Obi, to get his views on some of the expected reforms. Mr. Obi's extensive professional journey includes notable roles at top-tier law firms in the country. He's also played pivotal roles within the Nigerian Bar Association, contributing his expertise for conference planning, as well as the Ethics and Disciplinary Committee of the Lagos branch of the NBA. He's widely acknowledged for his expertise in navigating intricate commercial transactions, complex litigations, as well as arbitration proceedings. He holds a Master of Laws degree from King's College University of London. I began our interview with his assessment of the judiciary under the immediate past CJN and what reforms the new CJN should focus on.
Justice Ariwoola did well. He gave us our new rules, and he gave us, in his turn, the salaries of the justices of the entire federation was increased by the president by 300%. To that extent, he did well. We should always look at from where we are coming from and in judging where we are. To that extent that this happened in his tenure, he did well. The challenges with the judiciary cannot be changed in a short time. He was there for barely 1.5 years. So we cannot, it will take a long time to be able to get us to where we would wish to be. Now speaking to the acting Chief Justice of the Federation, what I would say is that there's a lot of expectation. In her opening remarks, she had spoken to restoring the confidence of the judiciary. In the eyes of the common man, the judiciary isn't exactly smelling of roses presently. We hope that, be the head of the judiciary, that things will get better, and that hope in the eyes of the common man will be improved. So what do I think she should do a bit differently? We start with the issue of congestion. I think the Supreme Court is overburdened with a number of cases. We know that this is probably because the Constitution gives wide latitude to the kind of cases that can come before the Supreme Court. Until the Constitution is amended, hopefully by some alteration, we can look at some things that can be done in the intervening period, such as discouraging certain kind of cases to come before the Supreme Court, such as stay of execution, cases bordering on stay of execution. I see in the new rules that they have taken up things like that. Even things like divorce, it should be discouraged, and maybe mediation the mediation portion of the rules be activated for people who are so minded to come to the Supreme Court on issues bordering on that. I'm a senior advocate, but I equally know that the members of my rank equally, especially those who are intending to join the fold, equally add to the volume of cases.
Because it's part of the pre-qualification.
It's part of the pre-qualification. So the chairman, the acting CJN by law or by regulation heads the LPPC. It's possible that those rules might be changed to reduce the number of cases that come to the Supreme Court. Equally, we can equally look at looking into giving some priority to some civil cases. There are cases that I remember going to the Supreme Court once and meeting my boss, my former principal, and seeing a case. And I left working for my former principal about 21 years ago. I saw a case at the Supreme Court that was coming up for hearing. I could still remember that case. Some of these cases have led to, when we talk about the ease of doing business, it has equally, so maybe cases of commercial nature should be fast-tracked and given the light of day. And I equally think our colleagues, lawyers, should stop, filing frivolous appeals. And those costs should be on a full indemnity basis. Probably people will think carefully before they file those appeals.
Let me take you back to something you said earlier, and that's when you talked about the pre-qualification for taking SEAL. Like some of your colleagues will bring all manner of appeals because, it counts towards attaining the rank of SAN.
Yeah.
Do you think that it's time to take another look at those qualifications? As a way of decongesting the course, just like you've suggested, and perhaps relax some of these, or maybe perhaps those qualifications are okay and we just need to, just be sure about the cases that we bring forward to appeal?
I think it's a good system. Maybe we can tweak it, maybe we see some decisions in the Supreme Court that speak to some of these cases being litigated because of the purpose, which is actually true. But maybe we can reduce the number there, maybe increase the number in the Court of Appeal.
People don't get desperate and they're just taking all sort of cases.
Yes, because the Supreme Court is already overburdened. Some of the cases, maybe there should even be a financial value to some of the cases. There's some of the cases, I've witnessed an instance where somebody's case was over a matter of about 1.5 million naira. Why should a case of 1.5 million naira get all the way to the Supreme Court? A past justice of the Supreme Court said there was a case of arson of goats that came to the Supreme Court. Why should cases like that, say for things like death penalty and constitutional matters, is a policy court? Another thing I think that can be done with regards to the congestion, in England, not too long ago, the Lord Chancellor, the Lord Chancellor, the Chief Justice, one of the two of them, brought back some retired justices of the court to come and help with clearing the backlog. There are constitutional issues around that.
Because I was wondering, is this something that we can try here in Nigeria?
I see no reason why we can't try it at the Apex Court.
Really?
We can get special dispensation, even if it's by act, to clear, I think, things like motions at the Supreme Court. I know that in the new rules, there is a provision for non-contentious motions. But we borrow a lot from England. I see why we cannot borrow what they did in England to clear up their backlog.
And we have a lot of retired
that are still very active and capable. In England, it was done very recently, I think in 2022. So why don't we bring those who are still active? We have motions, we have cases. Why not bring them up? We can get a special dispensation and help in clearing these cases. And then deal with, free up the courts to do other things. Yeah. Even help with the matters, the cases before the courts. Then the cases that are obviously not have no head or tail, dispense with them. the lawyers who create these cases for the court system strike down hard on those who abuse the process.
By way of cost.
By way of cost and by way of disciplinary action. Because many a time people know that those cases have no merit. And people know that what they're doing is wrong. Like I've given an example of stay of execution, stay of proceedings. You know that like taking up a case to bordering on the NIC to the Supreme Court. What are you doing there?
Let's come back and talk about our colleagues, lawyers.
Yes.
Talking about, we also have a change of leadership at the bar.
Yes.
And we just sworn in the 32nd president of the Nigerian Bar Association, the Senior Advocate of Nigeria, Martha Musigwe. But what are some of the things that perhaps the NBA itself can champion, in helping to decongest our courts and make the judiciary more accessible and free up the system so that more people, can get access to justice and exits too?
The NBA's role, in my own opinion, is to be act as a pressure group to speak up when things are going wrong, where lawyers have erred, to wield a big stick. The bar and the NBA has a role to play in wielding the big stick on its members to behave appropriately. So that is one role of the NBA that the new president has to take seriously. Another thing that the NBA, with regards to the new president, lawyers, we were regarded as learned people. Why they call us learned is because there is an assumption that we know. And in the history of our profession, it is believed that at a certain time, law was a profession strictly for the elite. The elite, from its history, the elite were seen as the enlightened. The enlightened were those who beamed light, who showed the way for others to follow. So we cannot be an elite group as lawyers or an enlightened group as lawyers and rather be bringing darkness to people by acting contrary to the wishes of people or what people expect from us. So what the expectation of any leader of the NBA is to beam that light, lead direction, be a catalyst for that reform. I don't believe in setting up any new, I don't believe that we should go about any new summit or a lot has already been said. What we just need to do is to see through the things that see through the things that have been said and see it to fruition. Let's stop talking and let's, even within the framework of what we have, let's actually walk our talk and do. If we do even up to 50 or 60%, we will be the better off for it. Because like what I said, words fly away. When I started speaking, words fly away and examples inspire. If we walk our talk, we'll be the better for it as a country and as a justice system.
Because you said lawyers know something about everything, let me round off with talking about the state of the economy. I mean, a few days ago, we were recently confronted with this sudden price hike, and the NBA has come out to describe it as harsh. But how are you reading all of these things? What would be your message to government as to how to deal with all the hardship that so many people are facing right now?
I think policy should always wear a human face. Subsidy removal is inevitable because subsidies give room for theft of a grand scale. But maybe what government should look at is the palliatives that to cushion the effect of the fuel subsidy, of the fuel removal of subsidy that is imminent. Maybe look at the palliatives a bit more, maybe public transportation, electricity. So while I support what MBA is saying, government should look into ways of ameliorating the plight of the people, because everyone gets caught up. If you're an employer of labor, how much subsidy can you subsidize people? How much can you subsidize people? Are you earning, is your own income going in leaps and bounds to be able to meet that subsidy? But I know that the government is bleeding, and I'm sure, hopefully, they will come up with something, because I don't believe that government is insensitive to the plight of people. But I guess at some point, all the presidential candidates all said they were going to remove subsidy. It's now a function of how they would have approached it, implemented the subsidy removal. So all I would say is that let the government look at ways to assuage, ameliorate the effect of the subsidy, and one of which is affordable choices for transport. Like, I don't see why till now in Lagos we don't have big ferries on the waterway. I don't see why. Not only going to Ikorodu, almost everywhere is accessible by water. And you don't need to, all you need is to clear the water hydrant. One, it will create job opportunities. You just need to create marine police to police the waterway. Maybe by the marine police, I mean, the waterway might be used till 7 p.m. in the evening. And, that will be it. But if you ferry more people, then those who will go by car, then let them pay a premium.
Away from that interview, we turn our attention now to one of the high-profile breakout sessions at the recently concluded Annual General Conference of the Nigerian Bar Association. And I'm talking about the session on globalization and the legal profession. The session acknowledged that while many lawyers may perceive globalization as a threat, the current reality is that it is influencing the present and potentially the future of legal practice. Here are some of the highlights from that session.
The room is packed full with legal practitioners interested in issues of globalization and how it will affect legal practice. The immediate past Attorney General of Rivers State, Professor Zaccheaus Adango, speaks the mind of many legal practitioners when he identified a lack of capacity and infrastructure as some of the stumbling blocks to globalization of legal practice.
If the UK law can have access to participate or to practice law in Nigeria, can Nigerian law also have the right to practice law in the UK court? Certainly not. How many Nigerians are critical investors in the United Kingdom? I'm sure there are very few of them. And so, if you say globalization is give and take, we are going to be at a serious disadvantage because we don't have the capacity to penetrate the legal space in other countries. And that's why the average Nigerian lawyer is very skeptical about globalization. Because for me, we are not yet there. And happily, in terms of legal structure now, the existing extant legal structure in Nigeria does not permit globalized legal practice.
Drawing from their diverse experiences, other members of the panel say despite the challenges, economic integration and globalization will happen, and the legal community must be prepared.
Whether we like it or yes, globalization will happen in the legal profession. The question is, how do we ensure that we do not lose out from this?
In spite of our protectionist stance, and in spite of the fact that different people have made their choices, some are jackpying in order to take advantage of more liberal jurisdictions, some are feeling highly embittered that they're sitting here and other people are coming to partake of their national cake. We do already have foreign franchises in Nigeria, as we already know. We have mergers in Africa. We have alliance networks in Nigeria already, firms that have joined alliance networks. We have firms in Nigeria who have also established abroad. And that just goes to show you that rather than feeling embittered, we can all decide on which model we want to adopt in our own interest.
A UK legal practitioner also explains that his jurisdiction is open for anyone to practice and that foreign lawyers are not seeking to practice local laws.
In the UK, any international lawyer is free to offer legal advice and services in any law, including Nigerian law and even English law. The exception is that they cannot give themselves the title solicitor or barrister, which allows someone to practice the reserved areas of English law.
The consensus at the end of the conversation is that globalization is here and Nigerian lawyers must prepare, continue to learn, and position themselves to take advantage of the opportunities it offers.
I agree wholeheartedly with someone who mentioned something about, also upskilling our lawyers, bringing relevant courses into schools so that the kids coming through law school, coming through uni, can pick up skills that they can, when they land on the ground, they land running.
Let's now bring you a recap of some of the other top legal stories in the news.
We begin with the report that the Court of Appeal sitting in Abuja has struck out the appeal by governorship aspirants of the People's Democratic Party in Edo State seeking to disqualify the party's candidate Asue Ighodalo in the September 21, 2024 governorship election. The aspirants Arthur Esene and Anselm Ejezua had asked the court to set aside the April 17 judgment of Justice James Omotosho of the Federal High Court, Abuja, which dismissed their suits for being statute barred. Justice Omotosho, in his judgment, had held that not only did they fail to prove their claim that Mr. Ighodalo forged his voter's card, non-possession of voter's card did not constitute a disqualifying factor under the Constitution and the Electoral Act to deny a candidate from contesting election. In a unanimous judgment delivered by Justice Hamabarka, the appellate court affirmed the judgment by Justice Omotosho and held that the suit filed before the Federal High Court by Ejezua and 4 others was filed out of time and statute barred. After striking out the appeal for lack of merit, Justice Barka awarded a cost of 3 million naira against the appellants and in favor of Ighodalo, PDP and INEC. From the appeal court to the Federal High Court, also in Abuja, Justice Peter Lifu has reserved judgment in the suit filed by the All Progressives Congress against the Independent National Electoral Commission (INEC) over the conduct of local government elections in Rivers State. Justice Lifu reserved judgment till a date to be communicated to all parties after counsel in the suit adopted their written arguments. The court listened to all pending preliminary applications, including those seeking joinder brought by the Social Democratic Party, SDP, and the Boot Party. Former president of the NBA, Joseph Daudu, leading 6 senior advocates of Nigeria, asked the court to grant the relief sought by the plaintiff, while counsel to the Attorney General of Rivers State, Mr. Taiwo, and Mr. Femi Falana, representing the Rivers State Independent Electoral Commission, both challenged the jurisdiction of the court to entertain the case. They argued that the proper court with jurisdiction to entertain the case is the Rivers State Division of the Federal High Court. And we round off in Lagos, where the Federal High Court has fixed Thursday, September 12, to hear interested parties seeking to stay the forfeiture of some monies and properties linked to a former governor of the Central Bank of Nigeria, Mr. Godwin Emefiele. Justice Dende Dikpeolu fixed the date after listening to the submissions of all the counsel in the matter. Counsel to the EFCC, Bilikisu Buhari Bala, had told the court that the commission had complied with the orders of court with respect to advertising the interim forfeiture order pursuant to the final forfeiture order. She also informed the court that she has received 2 applications from counsel to Emefiele, Senior Advocate of Nigeria, Olaleko Ojo, but the applications were not ripe for hearing. She therefore asked the court for a short adjournment to enable her response to the applications. Counsel to the former CBN governor, Mr. Ojo, in his response, said that the applications filed were seeking to stay further proceedings in the forfeiture suit. The Senior Advocate of Nigeria is also urging the court to adjourn proceedings till Monday, September 9th, for the hearing of his client's application. Another counsel, Chibuzo Okpara, who appeared before the occupants of number 8A Adekunle Lawal Road, Ikoyi, one of the properties sought to be forfeited, urged the court to grant an adjournment to enable him file and serve processes on behalf of his client. After listening to all counsel, Justice Dipeolu adjourned the matter to September 12 for hearing of all applications.
And this is where we adjourn proceedings for today. Do remember to check out the Channels TV website for a replay of this episode of the program, as well as past episodes. Please also send in any feedback via our social media handles. I'm Shola Sheyele. Thank you for watching, and see you next week.